Yes, Mr. Dillon, thank you.
My name is my lord. Before I move on to my last 2 points, which should not take me more than 15 minutes, allow me to invite my ladies and my lords to look at this argument about Section 32(2)(a) from the perspective of the Supreme Court of Mauritius. To do that, we have to go to the brief, the proceedings before the Supreme Court, at page 717. Page 717, line 24. Mr. Person, Senior Counsel states, may I? It is a fact that I said it, but I would like to apprise the court of the following. This issue of whether he had seen the board resolution, that I did not see it, only came out in the course of the evidence before the court. Hence, I said, it was not our case that he had been negligent. We now turn to the page 718, line 38. We see how the court received that statement. Honorable Chui Chong, judge states, no, there is no problem, Mr. Person. Just a minute. Now, you will, of course, address us on this issue later on. But whether he was wrong, he could have been very wrong, but then, you know, he should have been given the chance at the discipline committee to give his explanation. And that is the point which was made by Mr. Duval. So why is all this Section 32 of the Labour Act then? He could have been very wrong, but then, you know, he should have been given the opportunity. That's the gist of the argument of Mr. Duval. It is not that he should have seen or he should not have seen the resolution. It's besides the point. And then at line 21, Honorable Chui Chong, judge states, that's precisely, Mr. Justice Magua is again hammering this point. The trial court didn't say, well, this was a miscalculation made worse by the non-inspection of a resolution. The trial court said this was his duty to do, unquote. Now, if I may take the court to the case of a respondent, MS page 1236.
Sorry to keep you.
1236?
Yes.
Paragraph 12.
The respondent's case.
Yeah.
Paragraph 12, isn't it? Yes.
At no point in time during the discipline committee was it suggested to Mr. de Spéville that it was his duty as accountant to verify the instructions of the aforesaid directors by requesting to see the relevant board resolution, and that he had been grossly negligent by relying solely on the ipse dixit of Messieurs Jean Piat and Alain de Spéville, or that document AP was a fabrication to exonerate him, unquote. And then, if I may take the board to paragraph 25 at page 1240.
1240.
1240, and that is where I would like to conclude. Before the board, UDL does not dispute that the principle that the President could not have regard to allegations which did not form part of the operative charge considered by the discipline committee. It, however, contends that the question of whether there was a breach of Section 32A of the Act does not arise because it did not grant the dismissal on Mr. de Spéville's failure to consult the board resolution. So there is no dispute about the principle. Their case is that it does not matter because that was not the ground on which we dismiss Mr. de Spéville. My answer to that is well, that is the ground on which the court relied to find that the mistake was unforgivable and warranted summary dismissal. So, and of course, my lady and my lords, you would have seen that at footnote 26, there are a series of English cases which have been mentioned. And these cases are only there for illustration purposes. They are example when in English law, cases, for example, there is a case of Spéville. It was a case when an employer was first told that they were investigating a loss of £3,000, and then, in a letter requesting him to attend a disciplinary hearing, mention was made of incorrectly reporting stock figures, not following financial procedures, and discrepancies in banking. At the end of the day, at trial, the case was that there was a reasonable belief that the claimant had stolen the £3,000. The conclusion was, since the accusation of dishonesty had not previously been put to the employee, the EAT held that the dismissal was unfair. All I'm trying to show is that there are illustrations in the English cases where the employer changes the tack, as they say, and the distinction is made between where there is a different labeling of the charge and where it is actually a different charge. And the test is where, had the final charge been put at the relevant time, would the explanation have been significantly different? In my humble submission, this is clearly the case here. Had Mr. Spéville been told that the reproach is that you should have seen the board minutes, then his explanation would certainly have been different. Now, if I may turn to the third point, which is my humble view of what are the applicable principles which relate to summary dismissal and when it is justified or not. It is common ground that the general rule under the Defense Labour Act was that an employer could not dismiss an employee for reason related to his misconduct unless he complied with Section 32. Section 35(1) of the Act provided that an employee validly terminated under Section 32 was not entitled to any notice or severance pay. The Mauritian law, however, evolved, greatly inspired by the development in France, and the following principles, in my humble view, can be stated to be correct. Firstly, it is for the employer to satisfy the industrial court that, firstly, it complied strictly with the requirements of Section 32, and B, that it was justified to do what it did on the basis of what he knew or ought to have known at the time it took the decision. Second principle, any failure to comply with a requirement of Section 32 would result in the dismissal being deemed unjustified, entitling the employee to severance allowance at the punitive rate, irrespective of whether or not the employer had a valid reason to dismiss. Third proposition, where the industrial court was satisfied that the employer did comply with Section 32 and could not have taken any other course but to dismiss the employee, it had to further consider whether the employer had been able to establish that the misconduct was of such a nature as to amount to faute grave, meaning faute misconduct depriving the employee of any entitlement. Otherwise, the industrial court was bound to order severance allowance at the normal rate together with wages in lieu of notice. Fourth principle, an employer who decided to terminate an employee for reason related to misconduct, but upon payment of notice and severance allowance, still had to comply with Section 32, meaning that if the dismissal was effected outside the 7-day delay, or the industrial court was satisfied that there could have been another sanction other than dismissal, then the dismissal is deemed unjustified and the employee is entitled to severance allowance at the punitive rate. And finally, and there I am referring to Mobilac and Rockbeer, it is illegitimate to allow such an employer to avoid the consequences of its contravention by inquiring as to whether he was justified to dismiss upon payment of notice and severance allowance at the normal rate.
Sorry, could you just repeat that one?
It is illegitimate to allow such an employer to avoid the consequences of his contravention by inquiring as to whether he was justified to dismiss upon payment of notice and severance allowance at the normal rate. For me, the case against UDL is this, my ladies, my lords. On the 21st of February 2007, UDL acted lightly when it dismissed Mr. de Spéville summarily, and then thought about what it had done, considered his years of service, considered his record, and came to the conclusion that it was appropriate to give him severance allowance at the normal rate. At least that is what the letters say. So in my humble submission, this is the best proof that we have that look at it objectively in the shoes of the employer itself. This is not a case where summary dismissal was justified, where summary dismissal was warranted. And this should force us to look at the prejudice in a different way, because obviously 7.6 million rupees is a big figure, and one can say how any accountant who makes that kind of mistake cannot be allowed to keep his job. The first thing I would say is that the question was, well, was it a kind of mistake which would entitle the employer to deprive him of notice and of severance allowance at the normal rate? But then I invite my ladies and my lords to look at the facts of this case. 7.6 million is not accepted. Out of this figure, a big chunk, 4 million, relates to a difference of interpretation of the word salaire. It is not a gross mistake. The mistake which are accepted are that he took 13 months instead of 12. And he has explained the pressure under which the computation had been done. They took October to October instead of October to September. And then there was a mistake about the payback, whether a payback was indeed part of remuneration. And what Mr. de Spéville says there is that I agree that a payback cannot be counted. I'm just not sure that it was a mistake in that case, because I am not sure that this amount was a payback. That is the state of the evidence. But he agreed that payback should not be counted. So, and when the learned magistrate says Mr. de Spéville admitted that his mistakes caused an overpayment of 2.5, I will respectfully submit that is not quite what he said. He said that he agreed that those mistakes he made in favor of Mr. Rivalan was in the region of 2.5 million. But he also said there were other mistakes made in favor of UDL. So he never accepted that there was an overpayment. He accepted that there were mistakes, however,
Well, did he produce a computation of his own to show where the position as to
In
whether...
fact, you will see that when I examine in chief Mr. Rivalan, Mr. Rivalan refers to a document prepared with the help of Mr. I will just go straight. I will not rely on my memory, and I will go actually to the actual page, if you will bear with me.
Thank you.
So it should be if I can take you first at page 573, which is the appellant's written submission. Which is the appellant's written submissions before the industrial court. Paragraph 6. 573, paragraph 6. Yes. In deciding the fate of the plaintiff, the court must not only take account of the fact that the amount has not been reimbursed by the person who benefited from this error, but worst of all, the beneficiary of this mistake, Michel Rivalan, comes to depone and would have it that he has been underpaid, and he states that the plaintiff has prepared a document which shows that instead of MR having to reimburse the amount of the paid, MR has been underpaid. But that, in my humble submission, is quite what happened. If we go to page 348 to 349, is the evidence of Mr. Rivalan. At line 21, Mr. H. Duval, et lors du comité disciplinaire, on avait demandé à M. de Spéville de faire un calcul concernant les choses qui auraient pu vous être payées, mais qui n'ont pas été payées. Je vous montre ça. Vous confirmez que c'est bien ça. On montre qu'en effet, il y a eu des erreurs factuelles, que certaines étaient en votre faveur et certaines en votre défaveur. The answer is oui. The next page, Mr. H. Duval, c'est M. de Spéville qui a préparé ça à ma demande. Vous avez parlé de management fees, and then it goes on. So here is to be, there was a document, milady. It was produced before the comité disciplinaire. Unfortunately, the proceedings were not put in front of the court. So there was a document, and here you will see that contrary to what UDL says, it is not Mr. de Spéville who did that on his own. It was at my request, for the purpose of a disciplinary committee, that a document was prepared to show what were the entitlements which Mr. Rivalan could have claimed and which was not paid. So my point here is that the magistrate, the London magistrate, is oblivious to that. She is focused with a so-called admission that there was an overpayment of 2.5. There's no such admission. There's an admission that mistakes were made, both ways. Now, if I may, and now move on to point 4, which is the 12% interest. What must be borne in mind is that the 12% rate which the Supreme Court awarded is provided for in our law. Now, I have relied on the case of Ukum as authority for the proposition that in Mauritius it is accepted that interest is given as a matter of course. And the authorities on which my friend relies are examples where the Supreme Court on appeal awarded less than 12%. In the case of Collège à Bourdonnais, which is at tab 1330, 1330. Let me pause here before I go to the actual text. I understood my friend to say this morning that the problem was that the court did not explain why it gave 12%.
Yes, that's what he said.
It only gave 12%, but there was no reason for justifying the maximum rate. My answer to that is that the 12% is provided for in the law. UKUM is authority for the proposition that it should be given as a matter of course.
What,
under the statutory provision.
Interest or 12% interest?
12% interest. It does not mention 12%.
No.
It mentions the provision of a law and say it must be given as a matter of course. And my friend says, well, and I understand him as saying, the court should explain why the 12%. Now, and he relies on the case of La Bourdonnais and Sienne, which is at page 1330. Now, you will see, my lords, my ladies, that in the case of Sienne, there is no explanation as to why it's 6%. At the end of the day, if we go to 1344, we read this. The appeal is accordingly dismissed with costs, but we amend the judgment by ordering that the interest at the rate of 6% be paid only on the sum of 86,048, representing servants' allowance. In this case, interest was awarded both on notice and on servants' allowance. And you have a single paragraph, you have a rate of 6%, and no explanation as to why this rate is used. Now, if we go now to the case of La Sémillante, it is at 1403. And the relevant part is at 1408. Last paragraph again. In view of what has been said, we allow the appeal and amend the judgment of the learned magistrate of the industrial court by substituting for the order setting aside the appellant's claim, one ordering the respondent to pay the amount claimed with interest rate at 8% per annum, which we consider to be fair and reasonable in the circumstances, and the amount claimed as servant's allowance with effect from the date of termination of the employment. The respondent shall pay the appellant costs both in court and an appeal. So we have two examples where lower rate than 12% was awarded, but no explanation as to why 6 or 8 instead of 12. Now, if we go to UKUM, which is at tab 10.
Sorry, could you, what's the page reference, please?
It's 1399.
1399.
99.
Thank you very much.
The decision of UKUM versus Ramdouya. And the reference I will cite is at page 1401. At the bottom of the page, we read, "It is a matter of regret that the learned magistrate, when delivering judgment in November 1981, more than 18 months after the worker's dismissal, did not order the employer to pay interest on the amount awarded by way of several allowance as provided by Section 36(9) of the Labour Act. Severance allowance is payable at the time of termination of an agreement. We can only repeat that the industrial court should, as a matter of course, order the payment of interest whenever an employee has to resort to court action to obtain what is due from him by way of severance allowance as from the date his employment is terminated. Failure to do so deprives the worker of his due and only encourage employers to withhold payment of severance allowance until so ordered by the court sometime years after." Unquote. In my humble submission, the position is this. The law provides for a rate. That rate has to be considered with the legal rate, which at the time was 8%. So yes, it is a penalty of sort, that the court should have the possibility of applying up to 12%. And Hukum his authority for the proposition that this is done as a matter of course. Now, it does happen, of course, that the court award less than 12%. But as we have seen in those two cases which my friend has cited, and I must honestly say that I haven't found many others where the rate was anything else but 12%, and certainly no case where a reasoning is put forward to justify one rate against the other, is that under our law, we start with a premise of 12%. And if there is some reason to give less, then that ought to be explained. But as we have seen in Collège La Bourdonnais and La Séminante, there was an explanation for giving less than what is provided in the law. Unless I can assist the board further, these are my submissions.
I think not, Mr. Duval. Thank you very much indeed.
Could I ask a
Oh,
question?
of course. I thought you...
6-1, sorry, I didn't speak up in time. 611, if you'd go to the judgment of the magistrate, please.
Yes, my lord.
This is her crucial self-address on the law, third line down. In the light of the above extract, it's for this court to determine whether the company had a valid reason to dismiss the plaintiff in the present circumstances. Was that correct?
It is, I believe, correct that it was for the court to determine whether UDL had a valid reason to dismiss in the present circumstances. I would say the question was whether it had a valid reason to dismiss summarily as it did. But then, my lords, there is reference to the authority of Fukan, as what our law is, and I have no quarrel with that. That is indeed the state of our law. My quarrel with the judgment, with all due respect, is that she said that it was for her to do it, but she does not do it.
Well, that's one point. The other point is to compare a question, is there a valid reason, with the test in section 32,
Yes.
1B1, cannot in good faith take any other course.
Yes. But what
And my question really is, she's given that self-direction on the basis of what was said in Allel Frère,
yes.
based on the 1963 ordinance. Do we need to look at the 1963 ordinance in order to decide whether it's still right to rely on what was said in Allel Frère?
In my submission, no, because our law has evolved, and even this board has on many occasions had to decide on what is the implication of section 32, the last one being the case of Total. And it is, if we start with Movilac and Rockbeer, there is a clear statement of principle that not every dismissal for misconduct is a justified summary dismissal. And as Lady Hale rightly pointed, all the debate in the case which make it to the Judicial Committee of the Privy Council was about whether it should be severance allowance at the normal rate or outright dismissal, like in the case of Grey Walls, like in the case of Ragobia, like in the case of Total. And we don't rely on Allel Frère anymore. Allel Frère was the base where it was first said that there is another form of dismissal which could be dismissal for misconduct on payment of severance allowance at the normal rate. Whereas, as your Lordship rightly pointed out in total, when we look at Section 32(1)(b together with Section 35(1), it is clear that for the purpose of Section 32(1)(b, there is only one kind of dismissal, and that is summary dismissal. The other kind, the distinction between faute grave and faute sérieuse, comes from our French heritage. But our law, as it is, look in isolation, forgetting RL, Section 32(1)(b, read in conjunction with 35(1), refers to only one kind of dismissal.
Yes. I'm grateful to you. Thank you.
Are you content then that we proceed on the basis of OTEAM, which was produced by the appellants?
With all due respect, OTEAM is a judgment of Supreme Court, which was referred to in a case of this Honourable Board, which is our highest authority. I would feel much more comfortable should the Board rely on its own authority.
I see.
Thank you, Mr. Bishop.
With respect to the last issue, as to the correctness of referring to, I simply wish to draw your ladyship's and your lordship's attention to the fact that Harel and Virasamy was referred to in the case of Mouvilac. Harel, as my learned friend has indicated, was referred to in the case of UTIM, which was again a decision under the Labour Act, and your lordship and ladyship had the benefit of some of your lordship were part of the panel which heard the case of Total. There also, your lordship, your ladyship will see that extensive reference is made to Harel. So my submission to your lordship and ladyship would be that although Harel was decided under the 1963 legislation, there was the Labour Act of 1963, if I'm not mistaken, and that was supplemented by another legislation called the Termination of Contract Service Board Act. And as I indicated to your lordship earlier, the purport of the 75 Act was to consolidate those two legislations. So my humble submission is that the test as enunciated in the case of Harel is still good law. Now, my learned friend suggested that it would be inappropriate or unfair to refer to the mistake which had been committed by the respondent in favour of Mr. Rivalan, because we have made abstraction, so to say, with respect to mistakes which were to the benefit of UDL. Now, with this, I would like to take your lordship to the resolution of the board. It is not contested that Mr. Rivalan offered his resignation upon the change in the composition of the board of directors. At page 645, the resolution speaks, les directeurs parlent de la demande de M. Rivalan de prendre sa retraite avant la prochaine Assemblée générale. Cette demande a été acceptée et est décidée à l'unanimité. Now, the point I want to make is that Mr. Rivalan offered to resign, if not to retire. He had not yet, I think it's common ground, that Mr. Rivalan had not yet reached the age of retirement. So that in that respect, when my learned friend speaks of entitlement, there cannot be any entitlement. Whatever payment was made to Mr. Rivalan was of generosity. I would like to perhaps refer your lordship to the Labour Act, where your lordship will see section 37, and we are not in the context of a compulsory retirement section, which is at page 1283. My lord, my lady. Any employer may deduct from severance allowance, or perhaps your lordship will forgive me, we should go to page 1279 first, 1279, I'm sorry. Section 34, payment of severance allowance, subject to section 35, an employer shall pay severance allowance to a worker who has been in continuous employment with him for a period of 12 months or more, where the employer terminates, or where the worker on or attaining the age of 60 retires voluntarily. Your lordship will also note that with the obligation to pay the severance allowance, there are deductions which can be made to the extent that the employer has made provision in terms of a pension scheme, and that is covered in section 37, where the employer may deduct from the severance allowance payment in terms of pension. Now, my point is this. My learned friend seems to suggest that there were entitlement to Mr. Rivalon. My response is that there can be no entitlement, whatever payment was made, over and above. Even the pension would have been out of generosity. So over and above the pension, the board decided to pay 1 year, une année de salaire, plus the ex gratia. So it cannot be said, therefore, that the magistrate or the employer overlooked the fact that there would have been errors which were in favor of UDL. Now, my learned friend referred to the case of Beauvillac, 791. Which is the judgment of the Supreme Court. I read, as submitted by Mr. Duval, it is settled law that under the above provision, an employer should not dismiss an employee for alleged misconduct unless the two conditions set out in 1B1 and 1B2 are satisfied. Conversely, if the two conditions were not satisfied, then the termination would be deemed to be unjustified. Now, the two conditions are set out just above paragraph 10. He cannot in good faith take any other course, or the dismissal is effected within 7 days. These are the two conditions which the court are referring to, not that there must be misconduct, and over and above misconduct, the employer ought to address his mind to the issue of whether he in good faith cannot take any other course. Now, with respect to an issue which your lordship raised earlier, whether the bulk of the overpayment related to the ex gratia payment, that is indeed correct. The bulk of the overpayment did not relate to the item une année de salaire, but it must also be said, however, with respect to the ex gratia, there was no dispute whether benefits should be included, salaire plus benefits. The issue was which benefit ought to be included. And as I said, Mr. Irala, the accountant who did the computation, said, look, to me, I agree that the decision was that he should receive ex gratia based on salary plus benefit, but the only benefit, in my humble view, which could be included were those which were as set out in the statutory emolument, statement of emolument, sorry. next issue on which I would like to address your lordship is in terms of my learned friend referred to the payment. I say whether one calls it gratuity, whether one calls it severance allowance, whether one calls it goodwill, makes no difference. My submission is that that payment in itself could not render the termination unjustified. And I say this, if the Supreme Court felt that the payment of the severance allowance at normal rate showed that UDL could take some other course, then the court still had to proceed to decide, in view of the fact that there were other charges which had been proved, was it justified for the employer to terminate by paying severance allowance at normal rate and the notice. That is something which the Supreme Court, in my humble submission, failed to do. Now, lastly, my learned friend contends that UDL succeeded before the Intermediate Court on the basis of its allegation that Mr. Spéville relied on fake instruction. It is true that UDL had challenged the evidence of Mr. Piat and Mr. Marc de Spéville and Mr. Alain de Spéville, but I want to stress the fact that the learned magistrate made no reference in his finding with respect to those issues. The Industrial Court was all along alive of the fact that the charge was purely and simply miscalculation of the benefit. But lastly, I think your ladyship would have asked earlier this morning the evidence of Mr. Iralal in relation to the computation. Your ladyship will find it from page 511 to page 516. These are the few points I wanted to make.
Could I ask one question?
Yes, of course.
It relates to your plea at the very beginning of the proceedings. If you've got page 38 handy, Mr. Persem. Paragraph 17.
Yes.
Defendant denies the averments in 22 and avers that notwithstanding the fact plaintiffs committed an act of gross misconduct not entitled to compensation, defendant suffered prejudice in 7.6 million, etc. My question is, A, the plaintiff has committed an act of gross misconduct. What was the act to which you were there referring?
I think I have always said it, be it before the Magistrate Court and the Supreme Court, the act of gross misconduct referred to the miscalculation. And I said it to the court that to the extent that that charge would not be proved, then UDL would not be entitled to summarily dismiss. But my point, as I said, that there were other charges proved which warranted termination by payment of severance allowance at the normal rate.
Thank you for clarifying that.
Okay.
It would appear there are no further questions to ask of either of you.
Thank you.
We're grateful to you both for the clarity and economy of your submissions before the board. We will now take time to consider our judgment.
I'm sure that myself, my learned friend, will join me to thank the board for the patience you have.
Oh, we have to be far more patient than we have to be today. Some of those sitting behind you will understand exactly what I'm saying.
Thank you.